Radical innovation starts with radical discussion. Talking about the future and what comes next with Project MedTech.
Hello, everybody. I'm Lindsay Deneen, Director of Marketing and Engagement at Project MedTech, and welcome to another episode of the Project MedTech podcast. If we can help you in any way, or you would like to suggest a future guest, you can email us at info@projectmedtech.com. If conversations like this are helpful, that's exactly why we bring people together at our signature events, the Midwest Showcase, the Startup Symposium, and Coming to America. For more on our events that include networking, education, and pitch competitions for startups, check them out at www.projectmedtech.com. We even have sponsorship options if your company is also dedicated to accelerating medical technology to impact patient lives. So reach out today to get involved. The Project MedTech podcast is proudly sponsored by Ward Law. Ward Law Office, LLC is a boutique law firm specializing in the practice of patent and trademark law. They are committed to providing inventors, entrepreneurs, and businesses of all types with personal and professional services and are flexible to meet your unique needs. It is their goal to both educate on how to secure valuable patent and trademark protection and to provide high-quality services at rates affordable to independent inventors, startups, and small businesses alike. Without further ado, let's dive in.
Okay, Jake, welcome to the podcast.
Thanks, Duane. Happy to be here.
Yeah. Wardlaw is a sponsor of the podcast as well, and but this is the first time we've had others on from Wardlaw, but we've never had Jake on. From Wardlaw,
my partner Amy,
which I feel like
Amy Ronaldo has been here.
Yeah. But this is. I feel like this is getting Jake from State Farm. We're getting Jake from Wardlaw. Anyways, Jake, an intro to who you are, what you do, your background in the IP legal space, and then tell me a little bit about Wardlaw as well.
Perfect. All right. So yeah, Jake Ward, patent attorney extraordinaire, founder of Ward Law Office. So we are an IP boutique, Duane, as you know. All we do is intellectual property law, which is patents, trademarks, copyrights, trade secrets, and all the agreements, with all of the above, licensing, assignments, joint development agreements, you name it. If it touches upon IP, it's in our sandbox, and that's what we work on. The history prior to coming over to the dark side, I like to say, and practicing law, I was an engineer for a number of years, actually in the tire industry of all things. So became very, very familiar with polymer and polymer chemistry, and eventually decided to switch sides and got into the legal arena. Worked for a firm up in Detroit, a large patent law firm there for a little while, and then decided to strike out on my own here about 10 years ago. Actually, 10 years ago, we formed Ward Law Office. There was 3 of us at the time. My passion has always been working with entrepreneurs and startups and small businesses. And so when we formed the firm, I had 100 clients follow me over from my prior practice, and immediately underwater there was with the 3 of us that started it. And so we've been on this sort of growth trend ever since. I think we just recently hired employee number 35. So we're no longer small, but we're in a dozen states now. It's one of the things that happened with our firm too, as it evolved over the years. That small thing called the pandemic happened, and we sent everybody home, and we learned that worked for our practice. Most of our clients, we've got about 1,400 clients anymore. They're all over the country, all over the world, and they don't care where we're sitting. The patent practice is sort of interesting in that it's federal law for the most part. And so our courthouse, the U.S. Patent and Trademark Office is in D.C., our Metro D.C. area. And for that reason, it doesn't really matter where we're at. And so we're virtual, and that's how we've continued to grow. Primarily in the Midwest, very, very strong presence in Michigan and Ohio. But yeah, like I said, all over the country at this point. Yeah.
Yeah, that's awesome. And I know, I don't know if you mentioned in the intro or not, but I guess Wardlaw HQ is in Tiffin, Ohio,
Yeah,
which
little small college
there's
town.
yeah,
Ohio's full of them, right? Yeah, we all have,
yeah, yeah,
we've got two actually here in
yeah.
Tiffin, but yeah, yeah,
I know this. Yeah, I my brother-in-law and sister-in-law went to Heidelberg
yeah,
University, and it's the only reason I really know about Tiffin. And to
yeah,
find out that there's two there is pretty crazy. So for the audience listening in, um, we're a global audience.
yeah,
We're in the U.S. We're in the state of Ohio.
yes,
A lot of people, I think when you think of Ohio, you think of the three C's:
that's right.
Cleveland, Columbus, Cincinnati, but there's Toledo, Dayton,
Yeah,
Athens, Youngstown,
yeah.
Akron, a number of other areas. And I guess, Tiffin probably wouldn't be on the
It's
top
not on
10
the
or
list.
15.
No, no, it's not. And there's nothing, there's nothing, magical about Tiffin, Ohio as being sort of HQ for Wardlaw office, other than it's where I grew up, and I have family here,
Yeah, right.
and we moved
Yep.
back to this area we lived in Detroit metro area for a number of years, and moved
Okay.
back, and this is where we formed the firm. Now, one advantage I always tell people is, to our practice is we being here in somewhat small town Ohio, we don't have the cost of living, let's say, that our counterparts
Totally.
in New York City or San Francisco or Atlanta have. And we pass that along to clients. We don't have the ivory towers. And so, as you know,
Mhm.
our billing rates, we price it. We have two different fee schedules, but for small entity, micro entity clients, it's like at least a 50% cut in pricing, and we have the advantage of being able to pass along that sort of low cost of operation that we have from where we're
Mhm.
at, being both a virtual, but with our handful of physical offices, in locations like Tiffin, it really is a
Yeah.
benefit ultimately to the client.
Oh
So
yeah.
it works. It works.
Yep. It makes total sense. I mean,
If
we've oh, go ahead, Jake.
No, I
Yeah.
was just going to say very quickly, you mentioned the three C's. Usually, because we also have clients that are global, right? The majority
Yeah.
of our clients are domestic, but we have a pretty strong basis outside of the United States of clients that we help with IP on. And my point of reference is Cleveland. We're southwest of
Yeah.
Cleveland, and
That's right.
south of Detroit, southwest of Cleveland. Usually, one of those two will resonate, and it tells
Well,
people where we're located.
yeah, yeah, it rings a bell. Yeah, yeah, totally. I mean, it's obviously, full disclosure, Project MedTech has used Ward Law for a number of things as it relates to trademarks, and you've really helped us with our IP portfolio. Even though, as a consulting firm, you'd think there's probably not much there, but we've kind of had the benefit of learning from you all the importance of various things as it relates to branding for us, which
Yeah,
is such a big thing. And
yeah,
and it's funny, this is one of those things where the podcast and our events helped us, not just our client portfolio and people in our network, but I think the conversation started at one of our
yeah,
events where
yeah.
we were just kind of chatting, and it was like, hey, we should set up
It
a call,
clicked.
and
It
then
clicked.
yeah,
Well,
that's right,
I think
that's right.
we were talking before we started the podcast, that when I'm not lawyering, because apparently I need to fill up even more of my time. I'm a professor at law school,
Hmm.
and I was teaching, and I just actually last night. And one of the things I tell my classes is every business has intellectual property. It doesn't matter what your business
Hmm.
is. I have challenged people to at my class and my students to point it to me a business that you think doesn't have intellectual property, and I'll tell you why you're wrong. Because
Yeah.
every business has a name. It's a
Hmm.
trademark, it's a brand, it's who you are. Most businesses anymore, in modern times have internet presence. They have websites. Well, there's copyright,
Yeah.
right? And you
Hmm.
start just going down the list, and intellectual property, is really, I mean, it's, yeah, I'm a patent attorney, so to me it's important, but really it is important to every business because every business has IP and in one shape
Totally.
or form. And
Yep.
yeah, and even in a consulting business, like you said, your branding and all the materials you supply, and yeah, there's lots of intellectual property there, and it's valuable.
Yeah. So let's dive in. You mentioned about your background in polymer. A bunch of clients
Yeah,
come over with the three of you.
yeah.
You expand. You're 35. A ton of customers all over the place. And Wardlaw sponsored our Coming to America event last year in Copenhagen. And so I know you have a really good presence in Europe as well.
Hmm.
And so I'm curious though. That's we went from 3 to 35. There's a lot of story in between there.
There
And so
is.
I want to know,
Yeah.
for me, I can tie polymer to med tech really easily, but what got you into life science? I know you do everything, but,
Yeah.
but,
We're
you know,
heavily into
carving into
medical
life
device and life
sciences.
sciences. Yeah,
Right.
exactly. And
And that's interesting. So what leads you there?
well, personally, my if we go way back, my undergrad degree was in biochemistry of all things. I found my way into
Ah,
the
okay.
tire and rubber industries. But
All right.
and there's a story there too. Following my girlfriend at the time, who is now my wife and firm administrator, Christy. Yeah,
Yeah.
and that was the job to be had, and so that was what I went into as a career. But past that, in addition to myself having that sort of life sciences and biotech background, colleagues here that have joined the firm over the time, good friends like Dr. Bill Zeeler, who was in the Coming to America event in Copenhagen, who you've met. PhD in biochemistry. Dr. Fernando Alberti, also a patent attorney with a strong bioscience and life science background. It's just something that over time we've naturally just sort of collected, all this experience at our firm. Um, some of it is intentional. I mean, we have intended to grow in the medical sciences and life sciences area. Some of it is just we enjoy each other's company and we're good friends and good people, and sort of wanted to work together. We're only on this planet for so long, Duane, right? And work is such a big part of it. So you might as well work with people who you like. It's what I tell
Ugh,
people. And
totally.
yeah, and so over time, that's definitely grown. And even though I would say we do focus, and I think our where we really excel is in working with startups and small businesses and entrepreneurs. We're very good on the education. That's why I teach. I think I was a teacher in a past life, and but even in our practice, I mean, we're very good at education and guidance and counseling, much more so I think than some larger firms might be. Um, but because we do good work, we also tend to attract larger clients. And
Mhm.
so, in the medical and space, I mean, the Cleveland Clinic is one of our larger clients. The Mercy Bon Secours Mercy Health Innovation Group is another
Mhm.
one of our clients, and lots of physicians and staff will spin out of those organizations to do their own startups, as you know, and we help a lot of them too. So it's a mix, to answer your question, it's a mix of who we have, and then because we do good work, we've tended to attract a lot of those medical device and medical technology clients over the years.
Yeah. Yeah. And so, as you think about, let's stick on the IP as people think about it right now,
Yeah.
which is probably like, the patents on the physical device itself and those types of things.
Yes.
And then I have some areas I want to kind of branch into. What are if you are getting um, we love these clients at Project MedTech where it's like, hey, I have this idea. Tell me what are my first steps if I want to make this company fundable. Like for us, that's our sweet spot. We'll
Yeah.
talk about regulatory, we'll talk about reimbursement, we're going to
Yeah.
talk about commercial strategy, we're talking about all these different things, pitch deck, storyboard, all of these things.
Yeah.
For you, when someone says, okay, what's my where do I start as I start to think about taking my first bite of the IT strategy? What is like your, hey, you got to start here first?
Yeah, no, it's all about initially very early stages. It's about that sort of discovery and the memorialization, is the term that we use, right? It's getting what you know out of here and into something physical, whether that's a piece of paper or
Okay.
whether you type it up and it's now on a hard drive somewhere, right? Something we offer a variety of different sort of ways of doing this, but it's what we call invention disclosure and invention disclosure forms. We've got our preferred forms. We have an electronic online form that applicants can fill out, and it's about collecting the information. The other part of it too is it is a partnership. It is every patent application is a collaboration between the inventor and their patent attorney, because no lawyer is ever going to be as much of an expert on your area of technology as you are, and we know that, and that's the way it should be. And it's also vice versa. I mean, we're here to help guide you and translate that technical into the necessary legal to try to protect your interest and to give you that value. I mean, you talked about how do I build the value and my company and all of this for investment purposes. A lot of that is the intellectual property. And it is like any other form of property. There is going to be an inherent value associated with it. Now, whether you've got 1 acre or 10,000 acres of property is the question. And but working with a good patent attorney, we can be there to help craft the claim strategy, which is how patents define the invention, and try to traverse the myriad of landmines that are out there in both the patent process and then even once you get the patent, enforcing it. I've had some people point to patent applications that they've seen get through before, and like, well, that person right there, they filed it themselves and they got it through. Well, yeah, they did, but what are the problems with it? Just because they got it past the first gate doesn't mean that it's going to be enforceable. And that's what we do. We're not only looking at trying to get the patent, through the patent process, but we're trying to give you something that is actionable, something that you can use and rely on for investment purposes and enforceability, to try to fence off your turf, to prevent those copycats from following you. And that's, again, it's a collaboration. So I think invention disclosure and then working closely with your team of professionals.
Okay. So the next piece on this, we've talked about patents and IP on the podcast before, so I don't want to belabor
Yeah.
the process
Yes.
of it. But one of the things I do want to talk about is, one of the things I mentioned before about what we got educated on, which was, branding and trademarks and registered
Yeah.
trademarks and what they mean. And I'm curious. So we've had different branding experts on the podcast in the last probably 50 episodes, like somewhere between 200 and 250.
Okay.
I think we've talked about branding quite a bit. And it's been kind of like a consensus, to summarize it, is like, hey, you have this initial brand when you start your company. Then you have this kind of brand either update or change when you go to market. And then you have this brand once you commercialize, right? And sometimes that's brand updates, sometimes it's
refresh.
wholesale brand changes. Yes, it could be a lot of things. So at what point does someone go, okay, I need to start thinking about trademarks now? Is it right off the rip? Is it at that second stage, or is it don't worry about it till you get to the third?
So it's a good question. There is a little bit of the good lawyer answer that I could respond with of it depends, right? Because every business is different. Every business is different.
Yeah.
And I think the question could be posed a couple different ways as well. I mean, at what point should a business be concerned about registering their trademarks is different from at what point should a business be concerned about their trademarks. I think that latter question, at what point should a entrepreneur be worrying about their brand and their trademarks? I think that's day one. I mean, how are you going to be recognized in your industry? And picking a good mark, a good brand at the outset, I'm not going to say it's going to make or break your business, but it will have an impact. And so a lot of times, being diligent and being careful about selecting your brands up front is something that should be very high on the entrepreneur's priority list. And by the way, I'm not
Yeah.
if you're hearing me, I'm not saying go out and spend a lot of money and do a lot of filings. This is more about picking and selecting, a good mark, something that's going to be recognizable, to your customers, not going to cause confusion. No one's going to go to another company thinking they're coming to you or vice versa. Um, and you're going to find that is just like patents, something that's going to build value. In the trademark context, we call it goodwill. The consumer is going to come to recognize a certain level of quality and service associated with that brand over time, and that's one of those things that helps build value in your company for purposes of investment, and future exit if that's part of the strategy. So I think
Yeah.
thinking about that and being very careful and work with a professional, to make sure you're picking a brand that's not going to cause what I call the repainting of the trucks moment at some point in the future,
Yeah.
right? Where you become popular and all of a sudden you get hit with that infamous cease and desist letter because you weren't careful
Mhm.
up front. I think that's important and should be done right out of the gate. Filings and registration, they can happen later sometimes. I mean, if you're very confident, you can file trademark applications on a good faith intent to use basis very early on. So even really before you started commercialization and started your sales, that plants the flag at the trademark office, makes you first in line, which is important because the process for securing trademarks is a first to file system, and it does serve to block others that file after you. But you get a certain amount of rights with trademarks simply by using. So there can be, and this is different from patents, but with trademarks and branding, there can be a little bit of a delay before you really invest in formalizing the rights, at the government agency of the U.S. Patent and Trademark Office. I suggest, again, talk with your IP counsel, let them guide you, be diligent and be careful up front and think about it, really before you start going out and just advertising this is who you are. Um, and then rely on your counsel for helping you decide at what point it makes sense to actually spend the money to register the marks. Last thing I'm going to say on trademarks, since you got me on a roll here, Duane, is consistency. Consistency. This is something I see a lot of times with entrepreneurs very early on. They're still trying to define who they are and what this business is, right? And you'll see a lot of inconsistency sometimes in how they're spelling the mark, how it's being presented. You're going to find that if you are consistent in both the spelling of the mark and its presentation, you're going to more quickly gain value in your brand. And don't make it difficult for your consumers and your customers to figure out if that's actually you or not, right?
Yeah. Yep.
So consistency is the third
Yeah.
other thing I can say.
Yeah, I love it. I think, we were this conversation came about last week. We serve one of our clients is Balance Innovation Hub in
Yeah.
Akron,
Yeah.
Ohio, and we serve as entrepreneurs and residents there. I know you know them.
Yes.
We were having a discussion. It was a EIRs and some of the tech EIRs, and we were talking about sales and marketing, and we kind of got into this discussion of, I think some entrepreneurs at an early stage think marketing adds people into your funnel, your sales funnel. And at an early stage, marketing doesn't do that. Marketing and your brand is actually helping move people through your funnel, right?
That's right.
And being really consistent is a big deal, but having the trademarks, everyone wants a strong brand, but protecting that strong brand and
That's
making
right.
sure someone doesn't come in and just kind of take that from you
Yeah.
is really important. And that's where all of a sudden the trademark discussion was like, hey, I'm all for this. Obviously Project MedTech was we spend a lot of time talking about brand.
That's right.
But just make sure you protect that brand.
That's right.
And eventually it will add sales to the top. But really it's about working people through the funnel and kind of having that network. And anyway, so trademarks came up right away because it was like, you got to protect it.
I think to break it down very simply, you're right. I mean, what does the entrepreneur need to be concerned with? One, selecting a good brand, right? So that's something you do right at the beginning. and then protecting it is secondary. So once you've selected it, you've
Yeah.
committed. If now you see that there is this value, right? Maybe you have sales
Yeah.
or investors. All right, take the steps to secure it. Patents and trademarks. Again, one of the things I tell my students, just think of them as like fences. You're just building a fence around this thing as your property, so that if someone comes along and they jump the fence, as the property owner, you got the right to go over and toss them. That is
Yeah.
effectively what a trademark and a patent is. If you break it down very simply, it's just a property right. And
Yep.
and yeah, being able to make sure you're selecting the good mark, but then once you get to that point, where you've recognized the value, protecting it, like you said, is important and definitely should be considered.
I love that. Okay, so the next piece that I'd like to talk about here, and we talked about it briefly on right before I hit record, was everyone's favorite topic right now, which is AI.
Oh,
right?
yeah.
And,
Yeah.
we've talked about it a lot. It's a ever-growing field.
Oh, yeah.
It's very effective when used appropriately, but I'd love to get the legal side of things. And I know, there's very good prompts to use to get really good answers, but you have to be very careful. And I'll tell you an example of this.
Yeah.
And so, I will use Gemini frequently throughout the day. But I always prompt it with, if I'm using it to help me write anything or draft anything, even an email, a LinkedIn post, anything like that, I give it an email or a LinkedIn post that I wrote and say, hey, here's how I write. Here's kind of the style I like to use. Here's the new content I want to write about. Can you draft something for me? Okay.
Yeah.
And it gets you anywhere between 60 and 90% of the way there, depending on the day. Right.
Yeah.
And it helps you out. It makes things a little bit quicker. But the one thing that I thought was really interesting was I said, okay, cool. Here's my next thing. And I gave it a YouTube link, and it took the link and it wrote something for me. And I said, really? Did you watch the same video that I just did? And it came back to me and said, you caught me. I actually can't watch videos.
Yeah.
And then I thought to myself,
Yeah.
there's people using this to draft legal documents, strategies. And if people aren't prompting it right, or questioning it, you're like, whoa, this can get sideways really quick. So I want to hear, that's my perspective. I would love to hear from a legal perspective.
This is like you said, it's a hot topic overall, but it's something that I'm very keenly interested in. And one of the things I would say, our firm being a boutique firm, we're very flexible. And we leaned into AI early on. In fact, before it really was a thing, we were aware of it, because that's one of the interesting parts of being a patent attorney is you're always on the cutting edge. And so we have inventors, believe it or not, data scientists who are in this field. And so we were already aware of some of this happening. And so we've adopted, at this point, we've got 8, 9 different AI-based tools that we use at our firm, and we're always testing out new ones. And sometimes they work, and it's great. And sometimes we toss them to the side. It is a little bit of prompt engineering, like you were saying, Duane. Understanding how to ask the right questions. But one of the things that my staff tell me, Jake, you say the same things over and over again. I have I'm a what's it, not non-playable character is what my daughter would say. I'm an NPC. But yeah, one of the things I say over and over again is don't trust the robot. There is not a human mind behind that. No one is reasoning when they're giving you these answers. It's a machine that's very good at putting together strings of words into sentences. That is really all it is. Sort of a similar situation to you. One of the AIs I really like and again, we're also very careful. None of we don't use Gemini, for example. We don't use ChatGPT at our law firm. We use siloed AIs because we're very concerned about confidentiality. And I think it's just a matter of time. By the way, anyone listening to this, if you invent this, you're welcome. It's a matter of time before someone invents a way of figuring out when did someone put that idea into ChatGPT, because it's training out. So there's information flowing in and out of that system. And I know they say they anonymize it and all that. I think it's just a matter of time with quantum computing and everything that's coming down the road, that before someone says, oh yeah, this was put in to ChatGPT on this date, which happened to be before they filed a patent application. And there might be a problem. I think there's going to be a lot of litigation about this, in the future. So we use siloed AIs. We know exactly where our servers are. We know we're not training out. So data that's going in is staying in. It's confidential. But even with that, one of the downsides to LLMs and AIs is they tend to get lazy. I've noticed this. Like you say, all right, give me this list, and then it stops like halfway through. I'm like, so where's the rest of the list, robot?
Mm-hmm.
Oh, sorry. And then it keeps going, right? But if you're not aware of that it does these things as a user, it can be problematic. It is a great tool, like I said, and we absolutely use it. One of the things I've noticed over the past couple of years as they've become more popular is people will tend to go to Gemini or ChatGPT, and they'll arrive at our doorstep and they'll give us a 100-page printed document, plop on the desk. It's, all right, I've done your work for you. Here's your patent app. Here's the patent application. Can you file it? And it's 100 pages of gibberish. It's well-sounding gibberish, but ultimately it is gibberish. And it might have some qualities of patent application because the tool does tend to know here's what patent application should look like. But simply putting words under headings does not a patent application make. It is about the thought process, and every word matters. We don't get paid by the word as lawyers, right? And so I can write. I like the idea generally of writing concise, targeted, surgical style patent applications that really get to the heart of it. It's going to be a much more effective document for examination. It's going to be a more effective document for enforcement. But that's the opposite of what most LLMs do. They're intending to be verbose. They'll give you, again, 100 pages, just like that. But is it effective? Is it going to suit your purposes? Is it something that's actually going to survive examination, or is it going to confound your judge? Their eyes are going to roll into the back of their head because they're not going to want to read a 100-page document to figure out what it is you're trying to say. So I tell people, just be careful. I mean, it is a tool. We use it in a very particular way. Again, we've gotten very good with our prompts, and we work with automation engineers and things like that have helped make these things very effective. But we don't just simply plug in an invention disclosure and say, "Oh, here's your patent application." There's always thought that's going into it, always a human involvement. And I would encourage anybody who wants to use ChatGPT and all that, maybe think twice about that, or be more careful, be judicious. Don't necessarily give it your invention, but for background purposes, it's great. For strategy purposes, it's going to give you some information. It's a very effective way of learning about how the patent process works. But don't trust it. Always verify.
Totally.
Yeah.
It's so funny because when we do some of our bigger reports, opportunity assessments, commercialization strategy, regulatory strategy, there's a number of things we go get from Gemini deep research. And it'll give you 30-page, 60-page, things that you can read through and these nice reports as like a background research. I think sometimes people think like it's getting them way farther along than they think, because you got to go and read, and then you have to check the links, and are the links, you got to read the links as well. So anytime it cites something, go read that article, because sometimes there's a little bit of a hallucination there. And the conclusion it drew from that, you'll read that and go, huh?
No.
And so
Yeah.
it's a big deal. But it's funny because we'll have clients who will be like, hey, would you mind, I would like to see the raw data, like some of those research. And I always say, hey, I'm happy to send it to you because there are some really good nuggets in here. Just understand, the minute it starts to have an opinion, just be careful, because it's going to conflict against what our final report is in some scenarios, So anyways, I it's such an interesting tool.
It is. And I can tell you, too, I think the more people get used to it, the more aware they are going to become. Because I still remember the very first time I used one of these. In fact, I was driving. My wife was actually driving, and we were heading up to an event up at New Lab in Detroit. And I was actually, as patent attorneys will do, I was sitting in the passenger seat writing a patent application, trying to use my drive effectively. And I was trying out one of these tools, and I just remember seeing it, sort of spit out some initial sort of results based on the prompting. And I remember exclaiming, "Holy," because it was it was amazing to me. And I think that is the experience most people have the first time they see it. It's just, wow, that is amazing. But the more you do it, the more you realize the drawbacks, the more you realize where it fails. And that's why, as you said, it can arrive at different results. It can still hallucinate, although that is getting better, and sometimes having multiple models and some of the agentic AI can help with that. But it is something that ultimately, as a patent attorney, we have to stand behind the work product. We have to say we understand it, we agree with it. It complies with our standards, and it fits the strategy that we think is going to be most effective for you. And unfortunately, there's still a lot of people out there that still think it's magic and it's awesome. And they haven't yet learned all the potential pitfalls. And unfortunately, there's a lot of people, I think, in the coming years are going to learn the hard way. That they shouldn't have trusted the robot. The top 25 things that Jake says. Last thing I was going to say on that too, because I know this is a common question we get. It's like, well, if you're using AI, this is going to cut the cost, right? All this is going to be a whole lot more inexpensive. Not really how that works, and the analogy I give is this, with the invention of power tools, did houses become less expensive? Because you had a nail gun now and you had power saws and no, it made the process more efficient. It made the labor less intensive. But there's a cost associated with all of those materials and all this equipment as well. And prices of homes haven't dropped just because builders are using power tools. It's the same thing with patent applications. This is a piece of property. It is being built in a very, very logical, very thought out, planned way to try to serve what is each and every time a custom set of requirements. No company is a cookie cutter. Every company is custom. Every patent application is as well. And so that's our goal as your attorneys, to try to serve your best interests and try to make sure that this is going to be something you can rely on for investment and enforceability moving forward. And that requires thought, and you're not going to get thought from a robot.
Yeah, Jake, I love analogies, so I'm here for all of them. And I hope that when Lindsay, she's going to take this and cut it up into some clips as well. I hope she takes a lot of these analogies, because I am like, I love analogies. Anyways, Jake, really appreciate you hopping on. I know we've had to reschedule a bunch. Yeah, but it's always good to talk to you. And we will have a link to Wardlaw's website in the show notes. We'll have Jake's LinkedIn as well. And so up or down, and depending on the platform, you can click on it and check it out. But Jake, hang on for 1 minute. We'll chat offline. But thanks so much for doing this today.
Happy to be here. Thanks for having me.
Awesome.
Hi, I'm Freddie Coffey, Director of Marketing at Jumpstart. The Project MedTech podcast is proudly sponsored by Jumpstart Inc. Jumpstart's Trailblazer Accelerator helps Ohio's most innovative early-stage health tech startups fast-track their growth with tailored advising from serial entrepreneurs, non-dilutive funding to fuel their journey, and unrivaled access to a network of experts, resources, and investment opportunities. Whether it's improving patient outcomes, advancing digital health, or reimagining care delivery, Jumpstart provides the high-impact services and critical resources to bring big ideas to life. Learn more at jumpstartinc.org/startups.
Thank you for listening. At our core, we at Project MedTech are networkers, educators, and consultants. We meet you where you are to bring value and to create impact. We care deeply about helping medtech companies succeed right from the start, through to exit, by providing consulting and fractional services, hosting impactful industry events, and of course, sharing incredible guest insights like the ones you heard today through our podcast. Please reach out at any time if we can be of assistance. Check out our website at www.projectmedtech.com or email us at info@projectmedtech.com.